In 1973, a report was before the parliament regarding uh, increasing rate of the maintenance, rate of the divorce. Because as and when anybody moved the application for maintenance invoking section 408, a husband would divorce his wife to escape the liability. So, data was available with the parliament as to how provisions of section 488 were diluted by the Muslim husbands in order to escape the financial liability in the form of the maintenance. Therefore, Parliament decided to bring a sweeping change or reform or amendment in the old CRPC. And in 1973, entire CRPC was revised by making the sweeping change in various provisions of the old CRPC. Under the scheme of new CRPC, section 488 was replaced by a new section known as section 125 sub 125, and section 125 to 128 were enacted to create a maintenance liability for the wife against the husband, irrespective of her religion and community. Therefore, a wife who was unable to maintain herself was made entitled to claim the maintenance from her husband under the new section, that is section 125 subclass 1, and now the corresponding provision is section 144 subclass 1 of BNSS, which are as follows. Section 125 subclass 1 provides that if any person having the sufficient means neglects or refuses to maintain, number 1, A, his wife unable to maintain herself, or B, his legitimate or illegitimate minor child, whether married or not, unable to maintain herself, C, his legitimate or legitimate child not being married daughter who has attained the majority, where such child is by reason of any physical or mental abnormality or injury unable to maintain herself, his parents, that is his father or mother, unable to maintain herself or herself, a magistrate of first class may, upon the proof of such neglect or refusal, order such person to make a monthly allowance for maintenance of his wife or such child, father or mother, as the case may be, at such monthly rate as such magistrate thinks fit, and to pay same to such person as magistrate may from time to time direct. Explanation 125 1b further provides that wife includes a woman who has been divorced by or has obtained a divorce from her husband and has not remarried. Then the important provision relating to the maintenance under the scheme of section under the scheme of new CRPC is 127(3), which provides where any order has been made under section 125 in favor of the woman who has been divorced by or has obtained a divorce from her husband, magistrate shall, if he is satisfied that a amount has after the date of such divorce remarried, cancel such order as from the date of her remarriage. B. The woman has been divorced by her husband and that she has received, whether before or after the date of said order, the whole sum which under any customary or personal law applicable to the parties was payable on such divorce, cancel such order. C. The woman has obtained a divorce from her husband and that she has had voluntarily surrendered her right to maintenance, cancel the order from the date thereof. So, in the plain reading of section 125 as the new section 144 subclass 1 of BNSS lead to the conclusion that if any person having the sufficient means neglect or refuses to maintain his wife who is unable to maintain herself, the magistrate may pass an order directing the husband to provide the maintenance on a reasonable scale. The explanation B of the section 125 as subclass 1 defines the term wife, which is very important in context of the maintenance of a Muslim divorce. Wife included in its ambit the women who has been divorced by or have obtained the divorce. The object of section 125 was to ensure that divorced wife with insufficient means do not become destitute or as consequence of divorce. Therefore, under explanation B, meaning of the wife for the purpose of the maintenance was extended to include divorcee who has not remarried. This position was made clear that section 125 subclass 1 read with explanation B. A Muslim woman continues to be the wife even after the divorce and would be entitled to maintenance from her former husband beyond the period of iddat, provided she was resourceless and did not remarry. The rule of maintenance as propounded in section 125 subclass 1 read with explanation B was challenged in famous case Muhammad Ahmad Khan versus Shah Bano and others on the ground that section 125 subclass 1 of the CRPC is in conflict with Muslim personal law. So, Muslim personal law will prevail over it. That on the proof of some total payment made under the customary or personal law as contemplated in section 127 subclass 3 will entitle the magistrate to cancel the maintenance order passed under section 125 subclass 1. Now here I would like to clarify that section 125 subclass 1 read with explanation B were enacted by the Parliament with certain objective, and the objective was to prevent the vagrancy and destitution of a Muslim wife unable to maintain herself after the dissolution of her marriage. So, basically section 125 subclass 1 of the CRPC 1973 was based on the concept of gender justice, and a provision was made that where a wife is divorced, after the dissolution of marriage, that is on the expiry of the period of the iddat, the liability of the husband will not end. Rather, it continue even after the expiry of the period of the iddat in case the wife was a Muslim and her marriage was dissolved by means of the divorce by the husband. And in order to extend the liability of the maintenance beyond the period of the iddat, the meaning of the wife was defined under section 125 subclass 1 explanation B. And so explanation B to section 125 subclass 1 provides that wife means any woman who has been divorced or has obtained the divorce from her husband and has not remarried. Means any woman who has been divorced by the husband or the woman has obtained the divorce under section 2 of the Dissolution of Muslim Marriage 1939, she will continue to be entitled for the maintenance from her former husband, provided even after beyond the period of the iddat, provided she was unable to maintain herself out of her own economic resources, secondly, that marriage was dissolved by the husband. This provision was made by inserting explanation B to section 120, and this was made in order to address a situation which was prevailing before enactment of this provision, that under the personal law, under section 488, in both the situation after divorce and expiry of the period of iddat, wife was left at the mercy of the society and the state, in the state of vagrancy and destitution. Therefore, in order to prevent the vagrancy and destitution of a divorcee, provision was made that a divorcee will not be disentitled after the divorce, expiry of the period of the iddat, provided she was unable to maintain herself and did not remarry. This type of the provision for maintenance was made under the secular law, that is section 125 of the CRPC, which is applicable to all the women irrespective of their religion or community. Friends, section 125 subclass 1 read with explanation B to section was viewed by the Muslim husbands as in conflict with the provisions of Muslim law, and therefore argument started before the court that liability of the maintenance under section 125 in conflict with the Muslim personal law, and therefore Muslim husband are not bound to pay the maintenance to his divorced wife after expiry of the period of the iddat, because Muslim law permits maintenance only till the expiry of the period of the iddat. Therefore, the matter was challenged in famous case known as Muhammad Ahmad Khan versus Shah Bano on various grounds, including that it conflicts with Muslim personal law. According to the court held that provisions of maintenance under section 125 of CRPC is not in conflict with personal law. According to the court, the liability imposed by section 125 to maintain close relatives who are indigent is founded upon the individual's obligation to the society to prevent the vagrancy and destitution. That is the moral edict of the law and morality, and cannot be dubbed with the religion. The court further held that any sum payable under the customary or personal law and divorce to a woman would not disentitle her from claiming the maintenance, as held by this court earlier in Bai Tahira and Fazlun Bibi cases. In Muhammad Ahmad Khan versus Shah Bano, Muhammad Ahmad Khan, the husband, also argued before the court that under personal law he was obliged to maintain his wife only up to the period of the iddat. But this argument of the husband, Muhammad Ahmad Khan, was rejected by the court. After going through textual authority, the court held on this point. And the court held that the true position is that if the divorced wife is able to maintain herself, the husband's liability to provide the maintenance for her ceases with the expiration of iddat period. If she is unable to maintain herself, she is entitled to take the recourse to section 125 of the CRPC. And in this way, the court made a successful attempt in Muhammad Ahmad Khan versus Shah Bano to clarify that section 125 subclass 1 explanation B together dealing with the maintenance of a wife contemplates one situation, and that situation is where the wife after divorce is unable to maintain herself out of her own resources. And in order to address this situation, section 125 subclass 1 directs the magistrate to pass the maintenance order against the husband even exceeding the period of iddat. But the court clarified that where in the given situation, after the divorce, wife is able to maintain herself out of her own available financial resources, liability will cease to exist, and this situation is contemplated by Muslim personal law, which limits the liability to the period of the iddat. Therefore, there is no conflict between Muslim personal law and section 125 here. Section 125 visualize one situation and Muslim personal law perceives another situation. One situation, Muslim personal law perceives to the situation where wife is having the sufficient means even after the divorce. Section 125 speaks about the situation wherein the divorcee is unable to maintain herself out of the resources at her disposal. Therefore, court clarified that there is no. This decision of the Supreme Court in Muhammad Ahmad Khan versus Shah Bano was viewed as a direct onslaught on Muslim personal law by the Muslim community, and therefore agitation was launched in the various quarter of the country by the different social groups, political group, and this volunteers of the different organization. And a campaign was launched, a forceful campaign was launched that decision of the Supreme Court in Shah Bano case extending the maintenance liability beyond the period of the iddat is violation of rules given in Muslim personal law, and in this way it also violates the Article 25 of the Constitution, which guarantees the right to religion, freedom of religion. Therefore, the then government in power was forced to bring a law in order to dilute the effect of a decision given by the Supreme Court in Shah Bano case that husband will be liable to pay the maintenance even after the iddat period, provided the wife was unable to maintain herself and did not remarry. Section 3 of the Act 1986 is an important provision which entitled to the Muslim divorcee to reasonable and fair provisions and maintenance to her to be made and paid to her in the iddat period by her former husband. Reasonable and fair provision and maintenance to her children for a period of 2 years. Maher amount was made payable. All the properties given to her before or at the time or after her marriage were required to be returned to the divorcee. So, Section 3 of the Muslim Women Protection of Rights and Divorce Act basically codified maintenance right of a Muslim divorcee. Means, if after the passing of this act, it was provided that if any woman who is Muslim and has been given the divorce by her husband and is unable to maintain herself, then she will be liable to claim the maintenance under Section 3 subclass 1 of the Muslim Women Protection of Rights and Divorce Act 1986. And this section made a provision that after the expiry of the period of the iddat or during the period of iddat, Section 3 subclass 1 required the husband, Muslim husband, to make the provision for two things. That is, to pay that the husband will pay the maintenance to his wife during the iddat period, as well as on or before the expiry of the period of the iddat, the husband will also make for a fair and reasonable provision. And also provided that reasonable and fair provision and maintained under section 3 subclause 1 of the Act is not limited for period of the iddat. So, section 3 made a provision that in case of divorce, divorcee will be entitled to claim the maintenance not under section 125, rather she will be entitled to claim the maintenance under section 3 subclause 1A of the Act. And section 3 subclause 1A of the Act provided that the husband will pay the maintenance to his divorcee during the period of the iddat. At the same time, during the iddat period, he will also make a separate provision which will be called as provision for fair and reasonable provision. The court held that the reasonable and fair provision would be worked out with reference to the contemplated future arising need of the wife, the means of the husband, and the standard of the life enjoyed by the wife during the marriage. Such arrangements should be made in advance by the husband on or before the expiry of the iddat period. Therefore, the court held that there is no reason why such provision cannot take the form of regular alimony. In Iqbal Bano versus State of UP, the Supreme Court, following the Daniel Latif ruling, reiterated that liability of Muslim husband to his divorced wife under section 3 subclause 1A of the Act is not confined to the iddat period. Rather, he is liable to make the reasonable and fair provision for the future of the divorced wife, which obviously includes her maintenance as well as fair and reasonable provision. This future provision must be made within the iddat period in terms of section 3 subclause A. It was stated in this case, Iqbal Bano case. In Shamim Bano versus Ashraf Khan, again the Supreme Court dispensed with the requirement under section 5 and held that application under section 125 CRPC is maintainable even if the option to be governed by the provision of section 125 to 128 CRPC is not declared. Option to be exercised under section 5 is was dispensed with in case of Muhammad Abdul Samad versus State of Telangana and others. This is the latest ruling on the scope of section 5 of the Muslim Women Protection of Rights and Divorce Act. In fact, section 5 of the 1986 Act requires that where the parties are wishing to be governed by section 125 of the CRPC, for the maintenance, they should make a joint application before the magistrate with their mutual free consent. If it is so, only then they can have the recourse of section 125. Otherwise, the maintenance right of a Muslim divorcee after coming into force of this Act will be governed and regulated by the Muslim Women Protection of Rights and Divorce Act 1986, especially under section 3 subclause 1A of the said Act. Again, this matter was challenged as to why the wife should not have the option either to invoke section 3 subclause 1 of the Muslim Women Protection of Rights and Divorce Act or provision of section 125, which is now under the Bharatiya Nyaya Suraksha Sanhita, is section 144 subclause 1, be allowed to be invoked by the wife. Means, wife who is aggrieved in the given circumstance, seeking the maintenance from her husband, the aggrieved party should have the option, should have the liberty either to claim the maintenance under section 125, now 144 of the BNSS, or she can go under section 3 subclass 1A of the Muslim Women Protection of Rights and Divorce Act. Why is there restriction? And in this way it was argued that this is suppression of the right of a Muslim, legitimate right, suppression of the legitimate right to the maintenance of a Muslim divorcee. Therefore, the matter came for consideration before the Supreme Court again in the case of Muhammad Abdul Samad versus State of Telangana and others. The Supreme Court of India on July 10, 2024 ruled that divorced Muslim women can claim the maintenance from her former husband under section 125 of CRPC, now section 144 of BNSS. The ruling was made in response to a challenge by Muslim man to the Telangana High Court order to pay him former wife 10,000 rupees interim maintenance. The man argued that 1986 governed maintenance claim in his case. The Supreme Court ruling clarified that Act does not prevent the divorced Muslim women from applying for maintenance under section 125 subclass 1 of the CRPC. Ruling also affirmed that secular statutory provision of section 125 cannot be superseded by section 3 subclass 1 of the Muslim Women Protection of Rights and Divorce Act 1986, which is personal part of the personal law. So now the picture is very much clear. After coming of the ruling from the Supreme Court in the Abdul Samad versus State of Telangana, and a clear picture is, legal position is that after this divorce, way has been paved for a Muslim divorcee to claim the maintenance either under section 144 subclass 1 of BNSS, or she can exercise the option of claiming the maintenance by invoking the relevant provisions of Muslim Women Protection of Rights and Divorce Act 1986. Before this decision, wife was having the option to go under section 125 only when the other party consented for it. If there was conflict between the wife and husband, that is between the claimant and the respondent, regarding the operation of provision of section 125, then a party would be entitled to go for maintenance only under the provisions of Muslim Women Protection of Rights and Divorce Act 1986, not under section 125 of the CRP. But now option is open to the wife, divorced wife. After the dissolution of the marriage, divorcee will have the 100% option or liberty either to invoke section 125 for claiming the maintenance, or to invoke section provisions of Muslim Women Protection of Rights and Divorce Act. So now in this way we can summarize that the latest position on maintenance of a Muslim divorcee is that so long marriage subsists and continue, being a wife, she is entitled to claim the maintenance under personal law, can claim the maintenance under the statutory law, that is under section 125 CRPC. Option is with her. after the divorce or dissolution of the marriage. Again, if she is unable to maintain herself and has not remarried, then until the remarriage, she is entitled to claim the maintenance from her husband even after the expiry of the period of the iddat. If the husband has failed to provide the maintenance to her during the iddat and has also failed to make the fair and reasonable provision contemplating the future arising need of the divorcee. If he fails to make these two provisions as required under section 3 subclass 1, divorcee will be entitled to the maintenance even beyond the period of the iddat. And the restriction that she is entitled to claim the maintenance after the divorce only under section 3 subclass A has also been removed. Now, option is also to go under section 125, now section 144 of BNSS. So, this is all about the maintenance of a Muslim wife as well as maintenance right of a Muslim divorcee arising out of personal law, read with maintenance right as codified under the secular law of the country, that is section 144 as well as section 3 subclass 1 of the Muslim Women Protection of Rights and Divorce Act. All these provisions together seek to protect the interest of a Muslim divorcee after the dissolution of the marriage, and effort has been made by the framer of the rule to prevent the vagrancy and destitution of a Muslim woman who has been given the divorce by her husband in any way, in any form. Thank you very much.